Thank you very much, everybody, for joining this afternoon. This is one of our regular decannars, looking to keep you updated with the latest developments in procedure and liability in quantum. I'm very pleased to be talking to you today and to have my esteemed colleague, Esther here as well to talk to you. We are going to split up this talk into three sections. We're going to have a period of from me on expert evidence with updates. We're going to have a period from Esther on witness statements and updates, and then we'll have time for any questions at the end. If you would like to ask a question, there's a Q&A box you should be able to access on your Zoom link. So please put any questions in there and we will try to get to them and try and offer what help we can. Why are we talking about evidence today? Well, obviously, it's key to any claim and any defence. And also, we were thinking about the intermediate track, and a lot of people have been giving us questions about that and our thoughts on that. I thought buried at the end of the new part 28 is quite an interesting new direction. It's 28.14.3, and it provides for standard directions on the intermediate track that the total length of the witness statements, of all witness statements for a party, shall not exceed 30 pages, and any expert report shall not exceed 20 pages. So clearly, with the intermediate track now in force and coming in force for personal injury claims, any accidents that are occurring from now onwards, I think expert evidence and witness statements and these little issues are going to be increasingly important, perhaps as satellite issues, very much as best practice issues, and making sure that you have evidence that's procedurally compliant. So it's not perhaps the most immediately interesting topic in terms of lots of exciting facts, but it is procedurally, I think, extremely important to be thinking about these things. So I'm going to kick off on part 35. We're going to look at the main cases since the summer and then see if we can put them into some kind of context with the intermediate track as well at the end. So back to basics. Of course, 35.1 is our lodestar, our litmus test, whatever you want to call it. It needs to be reasonably required. And of course, the experts need to be helping the court, something that can get forgotten, as indeed we should all be as legal practitioners under the furthering the overriding objective. 35.41 is a reminder that we need the court's permission. That maybe sounds obvious, but it's a very common scenario in my experience that a claimant will serve a report for which it doesn't formally have permission onto the defendant, and then essentially assume that permission will follow as night follows day. The kind of nudge, nudge, wink, wink, I've served it, it's, the cat's out of the bag idea, but actually it's worth remembering that can be a very dangerous assumption and a very expensive mistake to make if you don't go on to get permission. 35.42, I put in there as a reminder that you should, of course, be providing an estimate of costs and also the field, but also the issues which the expert evidence will address. And that's something that I think is often overlooked. From a perspective of a barrister, I will regularly do my pleadings and schedule for a claim, and then I will be next instructed at CCMC stage. And in the intervening time that's passed, there will have been directions questionnaires, but often it will be simply saying, the name of the expert perhaps and the field, but not necessarily the issues. And it's good practice, I think, for DQs and generally to be considering actually what's this expert going to tell us? Why is it reasonably required from that early stage when you're doing DQs to make your argument as persuasive as possible the first time the judge comes across thinking about the issue. We've got as well as I put the bottom there, the requirements to follow Practice Direction 35 and the guidance for the instruction of experts in civil claims. And then we've got the practice direction itself, which is important, really 2 points to really pick out. One is the expert should not assume the role of the advocate. And that's something to always bear in mind, particularly in cases where credibility is an issue. It can be very tempting for an expert to start finding facts and essentially arguing that somebody can't be telling the truth or is giving an impossible account, when in fact factual matters, of course, belong to the court and not the expert. The other point is, as an expert, you must make it clear when something goes beyond or outside your expertise. And this is something that regularly is ignored, particularly in my experience, where you've got some kind of a boundary between, for example, pain cases, where you've got some kind of physical, psychological boundary, or issues of brain cases, where your experts are kind of moving into other areas and trying to assist or trying to help or destroy a case, when actually they've gone beyond their remit. I also just put in paragraph 3.2 of the practice direction, which says actually an expert should always summarize a range of opinions. I put that in because it's very rarely done, and actually it's a good tactical point to keep in your back pocket, particularly if you want to push back against an expert, or if you want to, as a defendant, justify the instruction of your own expert. Ask the other expert, what's the range of opinion? Follow your procedural rules in PD 35, and once you have a range of opinion, you probably then have a reasonable requirement satisfied to get your own evidence and opinion on that range. We're going to look at some recent case law, very recent case law. We're going to look at one Booker first, which is a case about policing in Tanzania, quite a niche area dealing with a mine that was being, where the defendant was providing security for that mine, and the claimant wanted to get expert evidence looking at the use of force by Tanzanian police, effectively look at international standards of policing. So at first sight, that might sound a bit irrelevant to our day-to-day cases because it's quite an unusual factual scenario. But what we get from Master Stevens is a really useful summary, a kind of fairly quick guide to submissions you need to be making on Part 35, whichever way you're arguing. So it's set out there that evidence must be admissible and reasonably required. Kennedy and Cordia provides further guidance on what admissibility means. So will it assist the court in its task? Will the witness have the necessary knowledge and experience? Will the witness be impartial? And is there a reliable body of knowledge to underpin the expert's evidence? So if you're thinking about an expert, think about whether you can satisfy those criteria. I often say to judges, imagine the trial was beginning this morning. Would you be assisted by this to help you reach your decision? And that can often be quite persuasive as a submission if you've got the right kind of evidence, if that submission works, because the judge thinks, actually, yes, I do need help with that area. Again, reasonably required, we have the British Airways and Spencer authority that gives a bit of a gloss on the word necessary. So necessary rather than merely helpful. It's a sort of stricter test. Again, is it going to assist? And is it reasonably required? And when we're thinking about that, we're thinking about proportionality. So a good way to defeat expert evidence that maybe is quite helpful is if it only goes to, for example, a very small amount of quantum and is going to cost a huge amount to do by the time you've got reports and other size reports and conferences and joint statements and Part 35 questions. You can say, look, okay, maybe it's helpful, but we're talking about, I don't know, a tinnitus earplug or something in the context of a few £1,000s. It's not going to be proportionate to spend £40,000 on experts looking at that point. In Wambaka, Master Stevens does not want expert evidence on policing in Tanzania because he says actually it's a factual issue, and there are international standards, but the judge is perfectly capable of reading those standards for himself to identify a standard of care. He doesn't need a sort of policeman who's policed in different countries to come along and give him a kind of gloss on that. So where you can deal with an issue on the facts and by reading a manual, as it were, you don't necessarily need an expert. And there was an issue here that the CV of the expert wasn't particularly compelling. It didn't deal with the very specific area where mining was going on in Tanzania, and was simply a general policing experience relevant to a continent, which is not obviously particularly precise. So there was a lot of problems here with the expert not being informed by a reliable body of knowledge, too general in scope, and therefore the application was refused. But it wasn't a case that the expert was biased, or that the fact he didn't belong to a membership of a professional body was fatal to the application. So there is obviously always some discretion here, and it will proceed on a fact-by-fact, expert-by-expert basis. It will be case-dependent. There also wasn't a precedent here really for a judge, for a previous expert in this kind of situation. And I think really what the claimant was trying to do here was make an argument based on equality of arms or parity, because the defendant had such an advantage, or has such an advantage in this case, in evidentially understanding the scenario in this mine in this very particular part of Africa. And the claimant was trying to find some equality of arms, or a way of having some evidence to rebut what the defendant was going to say about how matters proceeded. But the judge acknowledged that, but said you can't use an expert to try and sort of bolster evidence. You need, where you've got a subjective opinion on what went on. Essentially, it will come down to the facts. So the end of the point says the court shouldn't be shy to limit such evidence. So it's a very helpful authority for a defendant, I think. Just saying, the starting point actually is no expert evidence, and you've got to work quite hard to convince a court that it's reasonably required. So key takeaways: is this simply a factual issue where you're trying to get a kind of mixed issue of fact and expertise? If so, you might be in difficulties. And CVs and tailoring your expert's experience to show that you've got specific knowledge of an area is going to help your application rather than being too generalized. And if you can find a precedent for where such an expert's been considered necessary, that's going to help. And just be careful about having the subjective opinion of someone and trying to use that as a way to fill gaps in evidence and in facts. So moving on to the next case, which is crypto open patent allowance. This is about hearsay and trying to use expert evidence from other trials. Something I've done actually before, and judges don't like it. And Mr. Justice Mellor in crypto really, I think, shuts the door pretty firmly on this practice. The idea here is that we can use experts from previous cases to bolster a certain practice that's going on in the current proceedings. The claimant here is arguing about manipulation of documents. It's a case about forensic analysis of documents, and other forensic experts who've examined documents have reached similar conclusions to the claimant's expert and use similar methods. So by relying on previous experts approaching forensic analysis in the same way, with the same methodology, with the same conclusions, that will then help the claimant's expert, in this case, to look like his methodology is sound. So that was the justification for it. The authorities are in the principles are in Rogers and Hoyle. So you can, of course, serve a hearsay notice, providing any other document or opinion evidence, and it's a question then of what weight attaches to it. And the court has a discretion to exclude under 32.1 hearsay evidence. So the starting point is that hearsay evidence is very much admissible, which would be very much my view if you rang me up and asked me about it. But this case is actually going in the other direction, saying, yes, it's admissible, but the court has the power to exclude, and you shouldn't be then assuming simply you can just adduce something by hearsay notice and say, well, here it is, it's now in the bundle, I'm relying on it, it's a question of weight. So it's a question of overriding objective being considered. Is there going to be a disproportionate cost to do with this? Are you duplicating evidence that you already have in the bundle? And here, Mr. Justice says, actually, yes, those things all apply, and I'm going to exclude the application to rely on this. So the reasons for that were, there was duplication of evidence already on this issue. Two, it was going to lead to a lot of cost because it was going to be very document heavy, dealing with all these other previous expert reports. And that was in the context of a very long and heavy trial with 30 witnesses. And there were essentially other ways to deal with the issue in terms of perhaps putting to the defendant in cross-examination individual aspects of these previous expert reports, or the fact that this methodology had been adopted previously. That could be dealt with by way of cross-examination, by way of carefully and skillfully editing sections of other areas, just to kind of basically throw in huge amounts of documents and say, well, it's hearsay, was not good enough, and it was therefore excluded. So be careful with that. Obviously, expensive application to lose for the claimant here, and they probably viewed it thinking it was going to be simply successful, and just the judge has said, well, it's a question of what weight I give it, but here it's excluded. So consider that, and don't obviously ramp up documentation unnecessarily when you can look at things in a more edited and careful way. Moving on then to the next case of Securio Limited. This is Mrs. Justice Bacon. This is a case about experts going beyond the scope of their expertise. We have a reminder that experts should be independent and should be within their expertise. And again, as we said before, not assume the role of an advocate. This is a useful case because it deals with issues of wider importance. It's actually, on the facts, quite a niche area. Again, it's about breach of a patent relating to the processing of calls in a call center. So it's a patent case, but actually it gives a lot of wider principles. And it deals with particularly this issue of where an expert doesn't necessarily know everything and they start researching to enhance their existing knowledge. And the point at which that becomes too much, and actually an expert's trying to teach themselves during the lifetime of a case about an issue that they're not properly expert in. And that's really what this judgment is about. So yes, you can do some further research within your existing knowledge of a field. Yes, you can do some background reading and understand the context of questions better. What you can't do is start to educate yourself essentially for the purposes of proceedings and start to sort of become an even broader expert during the course of proceedings because of issues that come up. That's very problematic, and that's what happened in Securio. So some helpful words again for perhaps potentially for both claimants and defendants here. For Mrs. Justice Bacon, she says, obviously experts should not be giving evidence on a subject outside their expertise. And from the point of their instruction, they are supposed to be a genuine expert in the relevant field, who the court can rely on and give weight to. And you can't have experts kind of moving into new areas and new matters outside their expertise, just trying to help or assist. It's not for them to stray into those areas. The better practice is to stop and say, no, this is outside the scope of my expertise, rather than venture a guess based on some further research. So here the expert in this case, had a very difficult time in cross-examination, and ended up saying the whole case was a nightmare. That was a direct quote. And essentially, her evidence was abandoned. So it was in the context of a patent case, but obviously an example of where an expert just simply runs out of steam entirely. So it's a good case if you ever got an issue with an expert's expertise, if you're concerned that they're moving or straying beyond it. This is certainly a case to cite, and the dicta of Mrs. Justice Bacon. As I said earlier, this comes up in personal injury quite a lot in the context of claims where you're moving from a physical to a psychological boundary, or a neurological to a neuropsychological boundary, wherever it might be, where you're straddling cases on different explanations for causation. It's useful, if you consider the experts going beyond their expertise, to be citing this. We're going to look then at Jennings now. This is about site experts, but it's also about facts and expert evidence and the relationship between the two. Jennings is a case about an occupational injury, and the worker's arm goes into an unguarded area of a lift shaft and he loses his arm. There are no witnesses to the accident, and both parties had instructed expert engineers, and there was this idea that the claimant could come along and kind of explain or show the experts what had happened, so essentially providing factual evidence. The judge was deprecated or critical of the idea that should happen. Huge issues arise if the claimant's effectively giving evidence to the experts, giving factual evidence, and you might perhaps have recorded that there might be ways through it, but essentially the judge is saying, look, you're going to throw up so many satellite issues here. It's not sensible practice. You've got pleadings, correspondence, statements. You can ask for the detail, such as height and weight, before you go to a site visit. The other point of this case was that both parties turned up with their expert engineering evidence, and it goes back to that point. Actually, you need the court's permission, and Mr. Justice Cotter was not impressed that two parties turned up and said, well, here's our expert evidence, and we spent a huge amount on engineers, and we just like you to sign off the order that we've got permission to rely on that. The judge was very irritated by that, because first of all, he said, well, what about a single joint expert? Couldn't we have just had that in this case? That would have been far cheaper and more proportionate. And more so, why is this reasonably required? Because in this case, it was accepted that someone's arm could have gone into this area and into contact with the moving part of lift equipment. And it was also accepted that there was a guard, further guarding could have prevented that, but it wasn't in fact installed in this particular site. So he just sort of effectively saw that liability issue is quite straightforward given those facts, and it's a good reminder. And I think single joint experts are something that parties often forget about, and judges who are more experienced often refer to older times where they were very much the norm. And now things have moved on and everybody goes off and gets their own expert evidence. But it's a good reminder of actually the single joint expert being perhaps a starting point in cases, rather than just an assumption that everybody will go off and get their expensive evidence. So Jennings is a good authority on that don't assume you're going to get permission, even if you both agreed something. Don't forget about single joint experts as a route through a case, and obviously be very careful about a claimant giving evidence in a way that's unrecorded, unregulated. It's going to lead to a lot of factual issues or satellite issues. Moving on to Nash. This is a case about a car that was destroyed by a fire. And in the first draft, or the first expert's report from the claimant, the opinion was the fire must have been caused by the car being defective. But at trial, the expert modified that and said, well, actually, it's on the balance of probabilities. So it's a case about the expert going from saying something must have happened to something that was more than probable happened. And the issue is that a big deal? You know, if we've established causation on both pieces of language. Claimant thought it was just a question of, you know, language, semantics, causation's established not on either way. But actually, that wasn't a submission that was accepted. It was an expert who'd moved quite considerably in his language and had other issues in terms of being able to establish causation. And so in that context, it was significant that he'd effectively changed position. And it seems to me that's a good example in this case of that you shouldn't be overstating your opinions as an expert, much like when you start a trial, you shouldn't be overstating your opening as a barrister. You should be careful and guarded. And the point is, if you do overstate, then inevitably you will change decision. And once you're moving your language as an expert or slightly changing your position, it opens you up to criticism, and it opens up the fact that the other side can say this expert shouldn't be preferred in their reporting. So again, an important point there, and I guess checking your expert reports, checking the language of it, and ensuring that it's appropriately, the opinion is appropriate and not overblown or overly dramatic or overstated. So we finish up then very finally. I said I'd talk about the intermediate track, so I'm just going to do a couple of minutes on this before I finish. So the intermediate track applies, as we know, to cases after the 1st of October or PI where the cause of action takes place, or accident effectively takes place before the 1st of October. There are some exceptions, you know about this. I think we've all had a lot of talks on this. The new part 28, as I said at the beginning of the talk, says oral expert evidence is one witness per party, unless perhaps you can get a second expert if it's reasonably required and proportionate. You can't have more than a 3-day trial, which is going to go hand in hand with oral expert evidence, isn't it? Because you're going to have witness statements, lay witnesses, and then 2 experts on each side. You're already at probably the end of day 2 on any trial timetable. So you're not going to get more experts than that and stay within 3 days. And expert reports shall not exceed 20 pages, excluding any necessary photographs, plans, academic or technical articles. So the rule makers have said 20 pages is the most, with a couple of exceptions. And those exceptions are effectively academic articles or pictures. So not actually CVs, for example, statements of truth, not medical records, reviews of that. You'd be commonly seeing that in expert reports, doing a trawl of all the medical records. And so interesting where we're going to go on this. Does it open up an argument that we should be getting out of the intermediate track if our expert evidence is much more complex than this and can't fit within the 20-page framework? You can see what the rule makers are thinking. They're thinking, we want expert evidence to be slim and efficient. We're not having long arguments. We're not having more than a 3-day trial. So let's keep everything really concise, really focused. So that, I think, is the intention. But what's that going to mean when you've got a much more complex case? It seems to me, if we look at all the case law we've just been looking at in the last half an hour, we've got questions of staying within your expertise being prioritized. So there's an argument there, isn't there, that we can be actually arguing we need a new separate expert to make sure we stay within our expertise. And that would then say, well, another expert, maybe we shouldn't be in intermediate track now anymore. We need to understand what 20 pages means. obviously kind of going back to our school days where we tried to make our essays look much bigger than they perhaps were by going to font 18 or something. I don't think you'll be looked upon favorably if you start doing really small fonts to get into 20 pages. I think there's going to be an issue here. There are not many expert reports I read that are within 20 pages. I think you're going to be having opportunities to argue that this is a particularly detailed expert, maybe asking for permission to go beyond 20 pages, maybe saying that you need a new expert because it's so complex, maybe saying it's going to be more than a 3-day trial. And this could be a way that claimant firms look to escape the intermediate track and argue for multi-track allocation. The other way of looking at it is actually a need to really focus your experts to make sure they are concise and they are complying with Part 35 and not going on long rambling discussions or narrative sections on past medical history or whatever. So it may be that actually there's just a tightening up on experts being much more focused, and that will be the result of this. But anyway, consider that with your expert reports. Is 20 pages going to be sufficient? Can you report within 20 pages without compromising your level of detail? And do we need a further expert to deal with more complex issues? And what's that going to do with our position on allocation? So lots to think about there. I will hand you over to Esther now to look at the issue of witness statements.
Thank you very much, John. John, I think you've still got control of my slides, so a bit sort of old COVID announcing style. I'm going to ask you for the next slide as we go through. So I'm going to talk to you this afternoon about witness evidence, specifically Part 32. The requirements all quite dry and not hugely interesting, but we're going to have a look at what happens when things go wrong. I'm going to look at some guidance on drafting. I'm going to look the ClinNeg context specifically, and then we're going to end by looking at vulnerable witnesses and an interesting case on that. So a little bit of a jump around. I'm specifically not going to deal with FD. That's a talk all on its own, has its own considerations. And I think quite often when we look at witness evidence, we end up delving into things like surveillance evidence and an FD. And I think that it means that we perhaps gloss over and move on without looking closely enough at Part 32. So we're going to look at Part 32 to start with. You've got it up on the screen, I hope. And you'll see there the general rule. And the point is that you'll see within Part 32 the power of the court to give directions to place a limit on the issues to be covered by factual evidence, limits on the number of witnesses to be called, limiting the length and the format of witness statements. So you've already heard from John, and he's been talking about the new Part 28, the intermediate track. And the relevant bit so far as witness evidence is concerned is 28.14.3b, which he's referred you to. The total length of all witness statements is going to be 30 pages, which is going to be difficult. And it's going to be interesting to see, much as as John was talking about with experts, how is it that you make sure that you're going to be able to comply with that? Is it going to be by limiting the number of witnesses? It's going to be tighter drafting? Is it going to be leaving things out? What about things like appendices? I saw somebody asked a question about that. What about exhibits? What about documents that are being referred to? Is it going to mean people trying to sneak around the rule in various ways? Or is it going to be the case that there's going to need to be applications to go outside of the track, or applications to have permission to extend the 30 pages? So I think it's going to be interesting. We move on to the next. No, hang on. Here we go. So Part 32.8, form of the witness statement. You must comply with the requirements in the practice direction. So it's not a may comply, it must comply. And Part 22 obviously contains a requirement in relation to the statement of truth. Make sure always when drafting witness statements that the correct form of words for the statement of truth is used. I believe the fact stated in this witness statement are true, understand proceedings for contempt of court may be brought, and so forth. It absolutely essential the right statement of truth is used, it's still the case that witness statements are sneaking through with, and other documents are sneaking through with the wrong statement of truth on. Please make sure they have the right one. In terms of the practice direction requirements, let's start with the basic. You can see up on your screen 17.2, paragraph 17.2 requires the top right-hand corner of the first page, this witness statement needs to say the party on whose behalf it's made, initials and surname of the witness, the number of the statement in relation to that witness, so this is first, second, third, whatever statement, identifying initials and the numbers of the exhibits, the date the statement's made, and the date of any translation. It all sounds pretty straightforward and perhaps a little petty, but it really does help. And it's very, very often ignored, and it's so easy to include it and not irritate judges. And a little later on, we're going to look at a case of Shoebury, where judges have taken a very dim view of parties who don't comply with that requirement. And as with so many things, it's easily overlooked, but can irritate one judge. And why irritate one judge for something so straightforward? Paragraph 18.1 of the practice direction deals with the body of a witness statement. The key takeaways from there are that the witness statement needs to be in the witness's own words. How many times have you seen a witness statement where a lay witness says something like, well, they fell below the standard to be expected of a reasonably competent whatever, or they failed to, in my opinion, they failed to exercise reasonable care and skill, or in a road traffic accident, you know, the defendant, in my view, failed to stop, slow down, or otherwise control his vehicle so as to avoid a collision, and he drove into collision with the claimant's vehicle. Cut and pasting from the pleadings doesn't help a witness statement. Incidentally, a witness who refers to themselves in the third person, it's a bit of a giveaway that statement's not in their own words. So be really careful. And it's very easy to do. We want to make the witness statement and the pleadings have a sense of consistency. It's very easy to slip into legalese. It's very easy to slip into reference to the party in the third person. Make sure whoever's drafting the statement is careful with those sorts of things. 18.2, paragraph 18.2 is important. Witnesses need to make it absolutely plain in their witness evidence which statements are from their own knowledge and which information or belief. And if they're matters of information or belief, where does that knowledge come from? What's the source of that? Again, we're going to come back to this in relation to statements produced particularly by legal representatives. So let's move on, John, to the next one if we can. So format, and this is going to be interesting, isn't it, with the intermediate track? John's already talked about, you know, are people going to try and squish up their expert evidence to get a 40-page report into 20 pages? Doesn't say what font you should use, but you'll see it's quite specific. It's quite prescriptive. Durable quality A4 paper with a 3.5 centimetre margin, you'll see is prescribed. Interesting, it reads rather quaintly now when you think these days of electronic bundles. But that's what the practice direction requires. Fully legible, so perhaps that touches on John's point about squidging everything together. Put it in a nice folder that's not going to fall out of, that's always helpful. And pagination is interesting. And this, I think, comes back to the don't irritate a judge if you can avoid it nice and easily. Numbered paragraphs, always very helpful. Bold for exhibits. I cannot emphasize enough how useful this is when you're on your feet, trying to find your way around a witness statement. Chronological. It's not included there, but it's sorry, no, the chronological is included. What's not included, but it's very helpful, is headings. So separating a witness statement out so that it's clear when you're glancing at it what topics a witness is covering, to make it as user-friendly as possible. And that's it. It needs to be a document that the judge can look at, first of all, understand what this witness is saying in a nice, clear, easy way. Understand what's coming from them, what's coming from elsewhere, and is expressed in a way that's easy to work through. Okay, so that's what the practice direction tells us about what it should include. Does it matter? Let's go on to the next slide if we can, please, John. Okay, so does it matter? Obviously rhetorical. Of course it does. Frequently, the courts deal with inadequate statements, they just get on with things. Things aren't drafted perfectly. There are a number of the deficiencies in the practice direction requirements, but the judge just cracks on. What's the problem? The answer, of course, is that it's risky, and it's a silly risk to run. As I've already said, why irritate a judge when you don't need to? And it's also important to remind ourselves that we've already had CPR 32.8 up on the screen. It's prescriptive. A witness statement must comply with the requirements set out in the practice direction. And 25.1, there's a power for the court to impose sanctions. So where you have a witness statement that doesn't comply with the with Part 32 or the practice direction, the court may refuse to admit it and also may refuse to allow the costs arising from its preparation. So let's have a look at Shobri and Patel, which is High Court case. His Honour Judge Pearce sitting in the Business and Property Courts in Manchester just last month. And there were a whole series of non-compliance with the rules in that case. They hadn't filed bundles correctly, basic rules relating to witness statements, hadn't been complied with witness statements that had been recently obtained weren't in the bundle. And every judge's bugbear, as I've already alluded to, PDF pagination that didn't match the pagination on the printed and electronic bundles not matching up. But the judge particularly, sorry, John, we can go back. There we go. Particularly, one of the things that irritated the judge was the non-compliance with the top right-hand corner. That's a paragraph 17.2, and he expressed in general terms that deficit, that the inadequacy of the bundles, the recent witness statements, completely unacceptable way of preparing for an important hearing, and importantly went on to consider costs. I would not expect a paying party to meet the cost of material that was not even put in front of me during the hearing. I'd also not expect them to have to meet the cost of the inadequate preparation of material that has led to available judicial time being wasted on putting right these failures of preparation. In that case, the judge said he went through the bundle and inserted in all the things that were required by the practice direction that were missing. Now, perhaps that's overkill, and most judges probably wouldn't go to quite the same effort or have been quite so troubled. But again, why irritate a judge if you don't need to? Let's go on to the next case. This is a translation. Oh, I'll come back to questions at the end. This is a translation case. Road traffic accident, claimant was injured. He's a Portuguese speaker. His statement was written in English. He provided his witness statement to his account, witness account to his solicitor, who was a Portuguese speaker. So statements in English, statement of truths in English, which was signed by the claimant, a statement of translation signed by the solicitor. First instance, judge said, well, witness statement is inadmissible, claimant has no evidence, and the case was dismissed. John, if we go to the next slide. So, on appeal, the court held the first instance judge, the court had retained a discretion to permit a defective witness statement to be used. However, here the defect was fundamental, and the judge was correct to allow it to be admitted at trial. And it's worth having a look at practice direction 32.23.2 requires that where a witness statement is in a foreign language, the party wishing to rely upon it must, number one, have it translated, and two, file a foreign language witness statement with the court. And practice direction 32.25.1, where an affidavit, a witness statement, or an exhibit does not comply with part 32, all this practice direction In relation to its form, the court may refuse to admit it as evidence and may refuse to allow the costs arising from its preparation. And you can apply for permission under 3225(2) to use a defective exhibit, and that permission may be obtained from the judge in the case where the court is proceeding. So in front of on appeal, there was argument about various authorities as to whether or not the non-compliance would render a statement inadmissible, but the judge felt that none of those really helped, and so we went back to first principles. And conclusion, key part of the judgment can be summarised like this. He said, in all the respects identified by the judge, this witness statement failed to meet the requirements of the rules. The rules about provision of witness statements by those who are not fluent in English provides an important discipline for litigants and their advisors and are not likely to be ignored. And when one steps back and thinks about it, that must be right. And it must be the case that if a witness is providing their evidence, it needs to be the evidence in their own language. They need to have expressed it in their own words. And that really the solution that was proposed in that case, I think by the claimant's solicitors, was that what they would do is they would translate the English statement back into Portuguese, and then the claimant could sign that. And the judge really wasn't happy with that. And again, you can see why. You're providing a translation of a translation, and it's no longer the witness's evidence. So let's move on to the next case if we can. So this is about lawyers giving witness statements, and what happens when a claimant's solicitor, any lawyer, fails to comply with the requirements of 32(8) and paragraph 18(2). This is a chancery case in front of Master Marsh. Defendants had applied for strikeout and or summary judgment, and the claimant had filed some evidence in reply, and some of that evidence had come from his solicitor. And the master took the point that the evidence that had been provided was deficient, as it failed to give the source of the information contained within it, i.e. there'd been a failure to comply with 32(8) and paragraph 18(2) of the practice direction. And what was said by the master here is that a witness statement that contains information provided by another person must provide the source of any matters of information and belief. The point is not without importance, because the accuracy of this information may be challenged at the hearing of an application or at the trial. The source of the information needs to be clear. It is of particular importance on applications made under Rule 24(2), where the court may be required to exercise a judgment about the quality of the evidence, both in what it says and does not say, and whether it makes out a claim or defence with a real prospect of success. And if we have a look, the next case is Punjab, which is over the next slide. Same master, Master Marsh, and I've set out the relevant paragraph of that on the slide there. And this is where, I'm being signing of exhibit sheets. We'll come back to questions. Sorry, I'll come back to questions at the end. So this is where you've got a witness who's employed by or an officer of an incorporated body. It's not good enough in providing the witness statement. Simply say, well, that entity believes this, or this information comes from inside this entity. So what Punjab is saying, you must identify the source. So that means the person or persons must be identified and named. A corporate entity cannot experience events and can only operate through the medium of real persons. Follows the source of evidence must be named person or persons. A failure to identify the source in a manner that complies with 18(2) will mean the court has to consider whether to place any weight on the evidence, especially where it touches on a central issue. So, and next one we're going to have a look at is Blue Manchester. This is a technology and construction court case. It's a cladding case. Application to strike out the D2's witness statements for non-compliance with Practice Direction 32, and also Practice Direction 57AC, because it's within the business and property cause. So there are some aspects that we don't need to touch on, but it's interesting to have a look at His Honour Judge Davis's conclusions in that case. There were failings in the witness statements, but it didn't justify striking out, and there was an unless order made. There was some guidance given about witness statements, and witness statements should be in witnesses' own words. We've talked about should be in the first person again. Should state the basis on which they're made, for example, a combination of personal recollection or contemporaneous documentation. The list of documents referred to in the statement must be properly identified by the statement. Again, it's all pretty common sense stuff, isn't it? And what he also says, it may be necessary to refer in the witness statement to documents as a means of explaining the evidence. However, care should be taken to ensure that referencing in statements does not go beyond what is necessary. The purpose of witness statements is not to provide a means of confirming a thread of correspondence. Any such narrative will form part of the evidence at trial. And one can see this happening quite often in applications where you have a solicitor's witness statement, which effectively does little more than reproduce and exhibit all of the correspondence on a particular issue. You can see the need for doing it in certain cases, but I think it's interesting that in Blue Manchester, the judge was really not hugely happy with that as an approach. So let's move on and have a look at striking out witness statements. So claimant brought an action for breach of contract. Case was about failing to give him some shares in a business. There was a 5-day liability trial and the claimant was successful. An assessment of damages hearing and some directions were made. Defendant decided at that point to put in some witness evidence in relation to the assessment, and the claimant argued that they were effectively going to factual issues that had already been decided on the liability trial, and the claimant applied successfully to strike out those parts of the witness evidence and parts of the counter schedule. And I think there's another slide if you move on. And some comments made. Disputed evidence lengthy and contentious, already been the subject of the proceedings. Some of it's entirely irrelevant, and some of it is obviously inadmissible as being collateral challenges to the judge's evidence and fact, as to which D1's issue is stopped, and therefore it's struck out as an abusive process. But in relation to those matters that were just lengthy and contentious, the judge observed that those weren't sufficient to justify striking it on their own, but they were factors capable of affecting the trial estimate and, in that case, the trial date. So some relevant considerations to bear in mind. Should we have a look at the next slide? Two cases on witness evidence in clinical negligence cases. The temptation, and I've referenced the two cases on the slide. When I came up with the title, I wanted to touch on the particular difficulty of lay witness evidence, particularly from clinicians in clin-neg cases, and the temptation that one often finds for them to be drafted as if they're an expert report. And I think it's important, whether you're drafting them or you're considering those that have been drafted by the other side, to analyse them carefully. Have they been drafted as if they're an expert report? Do they make it absolutely clear to what extent they place reliance on notes, on memory, or to what extent there's reliance on unusual practice? It's not infrequent that you find defendants' witness statements, defendant clinicians' witness statements, crossing the line from discussing their usual practice to starting to make assertions about the standards generally to be applied. It's unhelpful. It's unhelpful both sides. It's unhelpful for defendants because it's quite nice and easy cross-examination materials. It's unhelpful for claimants because it doesn't really tell you very much about what this particular clinician did or what their usual practice is. It starts to muddy the issue. It starts to muddy the water. So I think it's I think it's important to be quite clear when you're drafting or considering witness evidence, particularly from clinicians in Clin-Neg, to keep that in mind. The two cases I've put up on the slide, the first is Freeman, and this is really about sort of strength of witness evidence and about the balancing of records as against witness recollection in Clin-Neg cases. But it feeds into our discussion about what should be going into witness statements in the Clin-Neg context. So Freeman is a brain-injured child, injured at birth, and died sadly at the age of 12. The crux of the case was about verbal advice that had been given or not by a midwife in the period of time before the mother gave birth. And it was clear from the case the defendant had quite considerable issues with record keeping. The evidence of the claimant and her family the court considered was believable and consistent, and the observation was made that there was a requirement on them to deal with the whole event, the previous medical history, the history of the pregnancy, the caesarean section, the delivery, and beyond. And it was interesting that there was quite a lot of focus on as I say, the believability and consistency of that evidence in the context of having quite a large number of issues to deal with. The case is interesting as well as a review of Guestmin and the weight to be given to oral evidence compared to contemporaneous notes, and the observation that although contemporaneous clinical records are inherently likely to be accurate, it doesn't generate a presumption that has to be rebutted. Watson is a case from Mr. Justice Ritchie from last year. Claimant had gone into hospital 2 months later, went back again with a serious stroke, and the case was all about whether on her first attendance she was suffering from a mini stroke or a TIA, and there was much agreement in the case about on the facts of the case about how the claimant had presented, but the crux the crux of the case was about when she presented on the first attendance, to what were her symptoms? Did she have facial weakness? Which side? And she didn't give evidence, but her partner did. And he referred to, in giving his oral evidence, left side facial drooping, left weakness, and there were inconsistencies between his oral evidence, his written evidence, and the pleadings. And his written evidence, his evidence was at odds with quite a number of the documentation, quite a number of the documents. The reason I've put it in, it's really key, particularly in Clin-Neg, but across all areas, obviously, to double check and double check, triple check that witness statements are consistent with other documents, medical records, obviously, pleadings, expert reports, and be realistic as well in terms of lay witness recollection. To what extent is there, much as with when looking at talking about clinicians, to what extent are these matters being remembered? And if there is a really good reason why things are being remembered, put that in. So 2 cases worth having a look at. Let's go on to hopefully some practical guidance, drawing some of the things we've been talking about together. So obviously must be true, comply with the procedural requirements and the laws of evidence. We've talked about quite a lot of the procedural requirements, and evidential requirements too obviously need to be complied with. Think about structure and length. We've obviously talked about the intermediate track and the requirements there. But do make sure all factual issues are dealt with. There's absolutely nothing worse, obviously, than a witness saying, well, I did say it, but, go through the witness statement and it's not, whatever the key issue is, it's not there. Next slide, John, please. Careful with leading questions. The reason I say this is that the person taking the statement has a huge amount of control over the way in which the material is being presented. And it can be very tempting to encourage a witness along, but you get further away from their account if you lead them. So it's really quite important, I think, to try and be, whoever's taking the statement, to try and open things up as wide as they can for a witness, even if you then have to sort of, you know, edit and bring it narrower again afterwards. But try not to suggest things to the witness that means that you've ended up with an account that ends up being quite far from their original account. Think about language. Alex Laurie is a case I've put in there. Just to give you a little flavour of that case very quickly. Defendant was disputing a case brought against him by the claimant on the grounds that when she signed a document, she didn't understand the full effect of it, and she should have got some independent advice. The statement that she provided, though, was incredibly detailed, an analysis of all the case law and how it applied to her case. And the trial judge, unsurprisingly, said, well, if you have all that knowledge, detailed knowledge of all the case law, you must have understood, and gave judgment for the claimant. And on appeal, it became clear that the defendant actually had very little input into the drafting of the witness statement, and in fact had some issues with basic literacy. So is the language that's going in the witness statement, is it the language of the witness, or is it the language of the person who's assisting them in the preparation? Also, EDF and MAN, make sure that your witness statement doesn't include submissions. These are statements of facts rather than opinion. And I would have taken you to there's a particularly nice quote, but I think we're rapidly running out of time. Final absolute key takeaway: witnesses need to read their witness statement very carefully, and probably more carefully than they are used to reading documents. Read it again, check, make sure that the wording is exactly as they would want it to be, and that they agree with the contents. It causes, obviously, no end of difficulties when witnesses suddenly go, well, hang on a minute, no, I don't think I said that, or I've that's been misinterpreted, when it's there in black and white in their witness statement and they've signed a statement of truth. So you can avoid much of the earlier difficulties if you make sure that the witness makes sure that they check and that they are happy with the content. I think I put some bits in about vulnerable witnesses. I'm not going to talk to you about it, save, I think, just to go to the final slide and just to reference AXX, just because I think it's nice and useful. The claimant was knocked off his bicycle, didn't have a helmet, ended up with a traumatic brain injury on his case that led to him developing a psychotic disorder. He'd lost his job, he was detained under the Mental Health Act, and I think at the time of the hearing he was in supported accommodation, refusing to take his antipsychotics, refusing to be examined by defendant's experts. And Master MacLeod looked at the Practice Direction 1A provisions, considered that they were engaged because of his mental health condition, and the proposal that the claimant had made was that there should be a split trial to resolve the issue of causation. Then you can get an interim payment to provide some treatment to the claimant. If he had some treatment, he might be able to engage with the experts and participate more fully in the proceedings. And the master agreed, and it's just in there because I think it's important in a sort of case management context to see how vulnerable witnesses, in that case obviously a vulnerable claimant, is being accommodated within the case management structure to make sure that they're able to put forward their case. And so it perhaps shows that the provisions of the practice direction need to be considered quite broadly. So slightly off topic, but useful and I hope interesting. So, John, shall I hand back to you? Are you going to
Yes, thank you. You'll probably definitely have some lunch now. But thank you very much. We'll have a quick look at the questions. We had a question submitted, it's a travel law question, saying, should local standards evidence be served with a particular claim? And the answer to that is yes, it should. If you don't you're in difficulties, but quite frequently we see courts give permission out after that. But yes, definitely as a matter of best practice, you should be. And I think Frank Needham's put a question there as well. Yes, same point. You need to show local standards very much so. Yes, I wouldn't be trying any accident abroad without local standards evidence. We've got another question here saying, what would you suggest in terms of action to take if D receives a report from C, which reports to be expert evidence, contains an expert's declaration, signed statement of truth, contains opinion evidence, an author refers to themselves as an expert witness, etc., yet claimant says that he or she does not intend to rely on the report as expert evidence and simply relies on the document as part of disclosure? This clearly prejudices defendant in the sense that part 35 questions aren't responded to and restricted then on seeking clarification of the report. Gosh, there's a lot to unpack there. And to do that on the hoof, I'm not too sure. You're very welcome to email me on that. It seems to me that's very problematic conduct from the claimant. It runs completely contrary to the CPR in many ways I can think of. I've come across that in the context of things like counselling treatment records, which kind of quasi-expert evidence. There are various ways you could do that. I would be probably making an application to the court to refuse it for all the reasons that you've given there. It's a very problematic way of going about things. Either it's a witness or a fact, or it's an expert witness. To try and push it in as some piece of general disclosure seems to me that you could be applying to have that excluded. In terms of the chat, we had some questions here I think more for Esther. Does the date of the statement mean the date that the statement was signed? I would say yes, Esther, for that.
Yes, I think so. Yeah.
Is it compulsory that each exhibit sheet needs to be signed and printed with the claimant's full name and verified by a statement of truth? Esther, I'll give that to you, but my instinct is there's quite a lot on exhibits in Practice Directions 32, isn't there?
There is, yes. I mean, it's covered the exhibits, provided you're exhibiting things correctly and referencing them in the witness statement, then the exhibits are covered by the statement of truth. So you don't need a separate statement of truth on the front of each exhibit, if that's what the question is asking. The signing of exhibit sheets. And then we've got a question about 30 pages of general application, not just the commercial court. John, that's over to you, I think. The
30 pages of witness statements is
that, I think that was that the question. I don't know if that's a question in relation to witness statements or expert evidence, but I mean, my understanding is that it's a general application, not just commercial court.
It is. It's unless the court orders otherwise. So I suspect we're going to have a few test cases on this where people are going to be applying for longer expert evidence or going to be breaching the rules. There are going to be arguments about whether you can just put an appendix of medical records as appendix 1 and then have a 100-page appendix to your 20-page expert evidence. And
I'm sure people are going to try all sorts of things.
I suspect the court will be all right with that, actually, my view. I mean, I'm not going to, don't hold me to that, but I think the courts are going to be pretty pragmatic about this.
I think that those judges who are used to dealing with work in this area, I think are going to appreciate the difficulties that the requirements present, aren't they? And be realistic, as you say. So there's a question here about care expert. And this is probably one for both of us, actually, isn't it? Because we've got care expertise and witness evidence, witness statements conflicting, something told on our assessment. We obviously need to go with a witness statement that has a statement of truth. I mean, that's right. I mean, you can't, I mean, all of the sort of advice I've been giving you is not, there will invariably be occasions where witness evidence conflicts with other documents. Of course it will, because witnesses giving their account at that moment in time. So
I think one way you can deal with that, you can quote the witness statement. You can quote perhaps something you were told on assessment, and then you can say that you recognise that finding facts is a matter for the court. And I think a lot of experts will deal with it in that way. So
Mm.
you can identify perhaps discrepancy. Don't try and solve the factual issue yourself, but you can obviously say, if the witness statement is correct, then this would be my opinion on that. If what I was told on assessment was correct, that would have an impact in this way.
I
So
think
you
that's
just
got to be, yeah. So,
yeah,
sorry, John. I
that's
didn't
fine.
mean to talk over you, but I think that's got to be right, hasn't it? I mean, you've got, it's got to be, and it's always very helpful to have experts saying, well, if this, factual matter is not for me, but if this, factual scenario A, this is my conclusion, and if scenario B, this is my conclusion, because otherwise they don't do that. You just go back and ask them a question about it. So it's
Yeah.
much better if experts, bite the bullet and deal with it.
And you have
Um,
got the power as an expert, haven't you? You can apply to the court for directions. So it's worth remembering that as well. So if you get stuck as an expert, you can ask for help. Nigel Robinson's got a great question here. What's the court going to do? Likely approach the court if we start breaching these rules? Now, I think this is potentially quite interesting because there's two obvious answers. One is, well, yes, they're going to exclude them, and the other one is, you might say, well, maybe I shouldn't be in the intermediate track. And that's, I think, fascinating. I think there are going to be claimants agitating, saying, well, I've got too many witnesses. I've got too much to say. My experts are too complex. I can't do this in 3 days. Okay, it's a 50 grand claim, but it's not the intermediate track. And defendants are going to say, look at the rules, stick to 30 pages for your witness statements, stick to 20 pages for your expert evidence, and basically roll your neck in. And I think that's going to be, I predict, the battleground. And I think different judges are going to deal with that in different ways. And that's, my experience on allocation hearings. Historically, 5 judges would go 5 different ways on these points. So lots of satellite fun to happen. I don't know, Esther, what you think? Whether
Yeah, no, I absolutely, I agree, and I think also what if you're a defendant in that scenario, you just say, well, hang on a minute, there's already the case management powers that we've just been talking about, Part 32 and so forth. So it doesn't really matter where you go. There's still the ability of the court to limit the number of witnesses you have. So you already should be approaching litigation with that in mind. And I think you're right. I think different judges can take different approaches, whether they say, well, you go away and you decide which out of your 6 witnesses you actually need, or how it is you're going to comply, but you're going to have to comply, otherwise we'll just stop when you get to the 30 pages, or I don't know, it's going to vary. It's one of those fun questions we're going to be dealing with, isn't it?
I can tell you we're going to be doing a talk on it, yeah, in a
I
couple of
know,
years.
absolutely. I think there was a question as well submitted. There were a couple more submitted just before we came beforehand, weren't there? So there was a question about the local standards. Alex Thompson from Ashton's asked a question about planning the structure of a witness statement. I mean, I think hopefully we've touched on some of that. I mean, chronologically, please, and nice headings, dealing with things in a sort of logical, straightforward way. But other than that, I think it really depends. It's so case dependent. And I know Faisal Ahmed has asked us a similar sort of question about having some sample witness statements. And I think the difficulty there again is it really just depends on the individual case. So you can do some sort of general rules and guidance, and here's what the practice direction says. But in terms of on a case by case basis, it really just depends. John, I don't know if you had any sort of thoughts on structure of witness statements, what you found, or what
I think it's a good
doesn't
idea.
work.
I mean, it's a good idea for anyone drafting a statement to start off by thinking, well, what are the topics I've got to cover? So, you'd be starting with your heading with, the accident, the aftermath of the accident, recovery periods, care and assistance, effect on employment, concerns about the future, engagement with treatment, and effectively providing the facts you need to sort of the scaffolding for the facts you need to prove your losses and your general damages. So yeah, I think it's very good practice to do. I think what the issue we're going to have with the intermediate track is going to be, there's going to be a heightened focus on complying with the rules, which is going to mean, witness statements got to be all the things Esther's been talking about, witness statements, Part 35 in the practice direction for experts. There's going to be a focus on that and making sure that we comply with that. And probably a lot more focus. If you come along with a witness statement that's 50 pages and there's an application, I can imagine the judge is going to sift through it and start saying, well, this is a bit waffly here, and do you really need this section? And maybe these kind of satellite arguments, it's going to be
somehow that feels wrong, doesn't it? It feels too far, but who knows?
I think that's what's going to happen, and then obviously you've got to do all of that with fewer costs available. So claimant firms are going to be looking to probably say work more quickly, more volume of cases. So there's going to be less time, perhaps, to be more compliant. So it's going to increase pressures. But yeah, I fully predict there are going to be several cases on this coming out on further guidance and practice, and we will see whether this ends up being effective at streamlining these cases, or whether we're just trying to squish too much in to a sort of procedural regime that's not really fit for purpose. We will see. I hope that answers everything that people wanted to ask. You've got our email addresses on the slides. The slides will be emailed round. There will be a recording of this on YouTube if you want to put yourself through that. And thank you very much for coming. There'll be more decanours in the future, and obviously you're always very welcome to drop us a line, either personally or to the clerk's room with any questions. That's what we are here to do, is to assist you. And thanks very much, Esther. Thank you very much for.
Oh, thank you, John. Thanks everyone.